Hello everyone, welcome to yet another session of the daily news analysis by SRIRAM'S IAS, where we take up the important articles featuring in the Hindu newspaper and break them down for our understanding from the examination point of view. So let's start today's discussion by taking up the important articles from the New Delhi edition of the Hindu newspaper. Let's take up the first article. The first article which appears in the newspaper reads, Chhattisgarh implements PESA Rules. PESA, or what is called as the Panchayat Extension to Scheduled Areas Rules, is the PESA Act, which is to ensure the powers of panchayats and the local governance to the tribal areas. And recently the state of Chhattisgarh, which we know has a sizable tribal population, has implemented the new PESA rules of 2022 in its states. So this is an important polity development which becomes important for us from the point of view of GS2. So we'll look at this as to what exactly the PESA Act is. That becomes very important for us. Then what are the new rules and why has Chhattisgarh implemented it? So are the different states implementing the rules differently? So we'll take a look at this. Now, whenever we study the polity structure, we start from the center, then we take a look at the center's legislature, executive, and then we come at the state level. But there was a level of governance which was also envisaged as at the local level, be that at the panchayat level or at the municipality level, which we term it in the cities. So in order to facilitate the third tier of functioning of the government, we know that the Part 9A and Part 9B were added via the 73rd and 74th Amendment in 1992. This was for the panchayat and 74th was for the municipalities. So this amendment was added into the constitution to add that extra layer of governance. We already know this. Now, when the panchayat provisions were added under Part 9A, now these panchayat provisions were for normal villages, but what about those areas which have sizable tribal population? Those were left out of these Part 9A provisions. Then after 4 years, in the year 1996, the PESA Act, or a special act of parliament, which meant that in order to facilitate these provisions of Part 9A or the panchayat provisions, which meant that the governance powers of those local areas would be significantly given to the residents living in those areas. This act was formed to grant these powers to the tribal areas as well. So the scheduled areas are those which are referred to in the Article 244 subclause 1, which says that the provisions of the 5th schedule shall apply to the scheduled areas, right? So the 5th schedule of the constitution is meant for the governance of the scheduled areas and the scheduled tribes in the states, and other than Assam, Meghalaya, Tripura and Mizoram. These 4 states are covered under the 6th schedule, right? So these areas which were left out and which were included in the 5th schedule, the PESA Act was introduced to extend the provisions of the Part 9 of the Constitution to these scheduled areas identified by the 5th schedule of the Constitution of India. So I hope the genesis of the PESA Act is now clear as to why exactly this act was brought up. So this became the Panchayat Extension to Scheduled Areas Act, right? Then it was why was it being implemented? To guarantee self-governance through traditional Gram Sabhas. Now this became the major development through the PESA Act, wherein much in line with the provisions of the Part 9A, which devolved much of the functions and powers of the planning of the region, of the village, to the Gram Sabhas in the PESA Act as well. The nodal body which would take decisions on the local matters, the powers were given to the Gram Sabhas. This would ensure self-governance for that region. So the Gram Sabhas for people living in the scheduled areas were given these powers, and to provide tribals control and rights over the natural resources and conserve their identity and culture, right? So when you grant governance powers and autonomy to them, they have greater control and rights over their natural resources, and they can conserve their identity and culture as well. So that before the PESA Act was enacted in 1996 to provide for the extension of the provisions, we can, as we saw, relating to the panchayats of the scheduled areas. Now, talking about some of the important provisions of the Act and what is their significance. So, the PESA Act was enacted to ensure self-governance through Gram Sabhas, as we saw. So, this became the first important point with respect to the PESA Act, that the powers of planning and deliberation was first given to the Gram Sabhas. It recognized the right of tribal communities who are the residents of the scheduled areas to govern themselves through their own systems of self-government, and also acknowledges their traditional rights over natural resources. So, this is what the Act did, and in particular, the Act empowers Gram Sabhas to play a key role in approving development plans. So, this highlights the Gram Sabha's role in planning aspect of the tribal area or the village. So, the Gram Sabha will be approving development plans and controlling all social sectors. So, significant powers were given to certain areas, such as exercising control over the minor forest produce. So, those resources from the forest, some of them are termed as the major forest produce, which can be called as the timber or the wood which is collected. That becomes the major forest produce. And the minor forest produce is something known as which is non-timber. So, the flowers, the honey, all of these substances which are collected by the tribals and then sold into the market are known as the minor forest produce. So, the Gram Sabha gets the power in the PESA Act to decide on the regulation of this minor forest produce. Then, minor water bodies and minor minerals. So, the minor water bodies which exists in the tribal areas, the mineral resources, the minor mineral resources, the major resources would still be under the control of the state government or central government, as the case may be. And then managing the local markets with respect to these things and preventing land alienation. All of these powers, so regulating the land, water bodies, mineral resources, forest resources, whatever is of the significance at the local level, the controlling of that, the power is given to the Gram Sabhas under the PESA Act. And also regulating intoxicants among other things. So, all of these provisions are granted under the PESA Act to the Gram Sabhas, who will then implement and plan and implement these plans with respect to these particular areas. So, that became the significance of the provisions of the PESA Act. Now, what is the role of the states over here? So, the PESA Act is that act which says that the act is formed by the parliament, but its implementation is to be done by the states by making certain amendments according to the states. Since all the tribal population in all the states are not the same, some have more, some have less, so therefore its implementation has been given to the states' prerogative, and therefore they are expected to amend their respective Panchayat Raj Acts without making any law that would be inconsistent with the mandate of PESA. So, which means that they have to incorporate this act into their state laws. So, currently 10 states which have sizable tribal populations: Andhra Pradesh, Chhattisgarh, which we are talking about in this article, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan and Telangana have notified the 5th schedule areas that cover partially or fully several districts in each of these states. So, these states have notified the scheduled areas of their states and implemented the PESA Act in these areas. And after the PESA Act was enacted, the Central Ministry of Panchayati Raj circulated the model PESA Rules, and so far 6 states have notified these rules, including Gujarat. So, what are these new rules which the tribal ministry, the Ministry of Panchayati Raj brought in? These are the PESA Rules of 2022. So, what does these rules say? So, these are the new rules which add more teeth to the powers and provisions of PESA Act, which say that yes, the Gram Sabha is now going to have the higher power to deal with the local matters of the tribal areas. But what about the composition of this Gram Sabha? So, the rules go ahead and give a mandate that at least 50% of the members of these Gram Sabha will be from the tribal communities, right? So, the composition of the Gram Sabha also becomes equally important, because if there is not enough tribal representation in these Gram Sabhas, the whole point of letting the Gram Sabha plan and implement it according to the community's needs, that won't be able to happen. So, the rules mandate that 50% of the members should be from the tribal communities, and of them 25% should be the female members. So 25% of the Gram Sabha should have female members. These are the new rules brought in under the PESA Act, and these are the rules which the Chhattisgarh government has now implemented in its states. So this is the whole background with respect to the PESA Act. So we can remember that this is the extension of the Panchayati Raj provisions to the Scheduled 5 states, that is the scheduled areas. And what do the rules say? They grant more power to the Gram Sabha and make mandates for reservation of the tribal communities and specifically women in them. So this becomes the vital information from this article, and with this let's move on to our next article. The next article, which now appears on the screen, reads, "Withdrawal of the data bill was a bad move." Now this was a news which we covered a few days ago in one of our sessions, wherein we saw that the data protection bill, which was brought way back in the year 2019, has now been withdrawn after the Joint Parliamentary Committee, which deliberated on this data protection bill, suggested major changes in the bill. And responding to these changes, the Union government, despite making changes to the bill, withdrew the complete bill, saying that it will bring a fresh data protection bill in the parliament. So in the session we discussed as to how the bill takes its course. The Union government brings out a bill in the intention of making it a law on a matter. In this case it was the data protection bill. Then it is tabled in the parliament. Then a parliamentary committee reviews the bill and suggests some changes if it wants to. And if those changes are approved, the government makes the changes, or in this case, as we saw, the government withdraw the total bill altogether. So the article now starts from this point, criticizing this move in a manner that totally scrapping the bill altogether and bringing a fresh bill has certain criticisms and is not a very right move. So let's try to look at the arguments which the author is trying to make in the article as to why taking back or withdrawing the total data protection bill altogether is not a right move. So first of all, while withdrawing the bill, what did the government say? It was a short circular that was issued by the Minister of Electronics and Information Technology. This is the ministry which will take care of the implementation of the data protection law. So it states that considering the report of the Joint Parliamentary Committee, right, which had proposed 81 amendments and made 12 recommendations. We had covered this as to what the committee said and why did it suggest changes. So after it suggested, the circular says that a comprehensive legal framework is being worked on, right? This is the only line which they say, that a comprehensive legal framework is being worked on. And in these circumstances, the government proposed to withdraw the bill and present a new bill, again, that fits into the comprehensive legal framework. So can we say that this is a very short message wherein one is not able to really ascertain as to what exactly are they going to change, and if they are going to change something, when exactly is the new bill going to be tabled? So all of these questions still remain to be answered after the message came out. That is what the author points out, that the message is still vague. And on top of that, the Joint Parliamentary Committee, when it suggested changes into the data protection bill, it did not recommend withdrawing of the personal data protection bill, which we are talking about. So when the Parliamentary Committee itself did not suggest total withdrawal, why did the government think it necessary for the withdrawal of the bill? Then lack of clarity when the new bill will be produced. As I said, these vague words are not suggesting as to when the new bill would be produced. And most important thing is that the 5 years of hard work have gone into the deliberation up until now, which is still not able to bear fruit. How 5 years? So let's trace the development. In the year 2017, the right to privacy was identified by the Supreme Court in the K.S. Puttaswamy judgment as a fundamental right under Article 21. So after the right was recognized, the Union government set up the B.N. Sri Krishna Committee in 2018 on the basis of the right to privacy being advocated to form a suggest a draft data protection bill. So this committee set out to work and formulate a data protection bill, and it submitted its report to the government in a year time. And then consequently in the year December 2019, government introduced the personal data protection bill in 2019 in the Lok Sabha. So it presented the bill and as we trace the development, once the bill is presented in the parliament, it was then submitted to this joint parliamentary committee, right, in the year 2019, and the parliamentary committee gave its report in the year 2021. So last year it gave its report, wherein we saw that it suggested these 81 amendments and 12 recommendations. So now it started from the year 2017 and it is currently 2022 right now, and the bill or the data protection law for which there is a pressing need. We'll see in a few slides why there is a pressing need for the data protection law. So in spite of 5 years of hard work, the data protection law still is not able to see the light of the day. So this is a major concern, and in that light, withdrawal of the bill altogether can be taken as a bad move. So what the author then discusses about certain fault lines of the existing bill which the government withdrew. So what was the fault lines or some of the issues with the bill that the author highlights? First is the exemptions given to the state, which meant that the personal data protection bill is basically a law for where the provisions are made for the protection of the data of the citizens, right? Then apart from the protection of the data of the citizens, there are certain rights given to the union government or the government authorities, wherein they can intercept the data, or they have certain powers with respect to controlling of that data. And the author points out that there are various or expansive exemptions given to the state in this manner, where the entire application of the law simply as if it was expedient to do so in the interest of national security. What this means is that on the interest of national security or public order, the government or the state authorities could intercept these data or can use this data as it wants. So it became simply as if that the protection is being granted to the citizens, but the state authorities are completely exempted from these provisions, and there is no accountability mechanism or protection mechanism against the powers of these authorities. So that the author points out was a major issue with respect to this law. So there is no oversight on the government's decision on this manner. Second is that both the Joint Parliamentary Committee as well as the initial bill proposed a strong regulator, which we had seen this was known as the Data Protection Authority. This would deal on the major matters of controlling of data. But this authority has been given much powers, but very little independence or accountability. Who is to look into the matters of this particular body? That did not become clear. So that was the issue, another issue which the author highlights. And then the bill imposed a strong data localization mandate. What is data localization? Let's take an example of Facebook for this matter. Now, Facebook, when we log into Facebook, Facebook collects our data, but Facebook as a company is registered or situated in the United States of America. But the data from India is going to the USA. That this is where the concept of data localization comes in, where the countries felt that the data that is being collected from their own countries should mandatorily be stored in that country only. That is the concept of data localization. So it is a good concept which the government tried to bring in the data protection law, but it became very vague, and the specific aspects of data localization were not enumerated in this law. So this was the concept of data localization, which was again not dealt with properly in the data protection bill, is what the author feels in this article. So this was the whole background information with respect to why the bill got cancelled, and what the author feels is the are the issues and challenges with respect to the bill. Now, when the author also tries to trace why it is a bad move, so as we were discussing, why is there a pressing need for such a data protection law? So let's take a look at why is there a pressing need for a data protection law? Why, after even 5 years of the data protection bill coming in, since we are not able to see a data protection law, why more and more urgency is there for the law to take place? As we know that there are around 750 million internet users in the country right now, which are continuously expected to grow in the future. So which means that the people using smartphones and internet are continuously increasing. Then there is a strong push for Digital India with increased focus on digitization of access to health, ration, banking, insurance, and especially after the COVID-19 pandemic, which means that the digitization of the Indian economy and society is rapidly being taking place, and government is pushing also in that direction. Then there is greater focus on the interlinking of data as well, wherein the data that is collected from one service or one application is being shared by the other agencies. So that can be either through facial recognition, the Aadhaar data, or the Criminal Procedure Identification Act. These have been the major developments in terms of linking the data and usage of data. So the facial recognition system which has been brought, the CCTV cameras that we see on the streets, they are capable of facial recognition. So this data can be used by the criminal enforcement agencies and other agencies. So we can see that the network of data sharing and data collection has continuously intensified, and we are much more under the, we can say that the data is collected faster than ever. So this is the scenario with which we can see that the prevalence of data collection and data security, therefore, with respect to the citizens, has become very paramount. Then India has come up against the highest data breaches in the world. So that is also obvious when the users are increasing and there is no protection for the data, for the data dissemination. India has come up amongst the highest data breaches, where it has been reported that around 18 of every 100 Indians have been affected by data breaches since 2004, with 962.7 million data points being leaked. Every few weeks we keep hearing news about Aadhaar data being leaked, other data from the critical government agencies being leaked. We keep hearing about this. So the intensified use has also created one thing, that the nuisance of data breach and cyber security attacks that have continuously increased in the country. And with the geopolitical order now going into much more chaos, with Russia-Ukraine war going on, China setting to attack on Taiwan, the new frontier of warfare, that is cyber warfare, has taken up much more importance. And if India is not ready on that front, it might create great problems in that front. So that is why the need for bringing a robust data protection law is quite high. And in that manner, by spending 5 years on the law and still not able to implement the law becomes a reason of worry. And another point is that why the law is needed is that when you want to protest against the state action, we can go to the High Court and Supreme Court under the writ jurisdiction of the Supreme Court or High Court. But there are certain corporate companies as well who, with whom citizens can have problems with their data breaches. Now, writ jurisdiction does not follow for corporates, so this means that there is an absence of a robust protection system wherein the grievances which citizens have from these corporate companies which collect the data, which can take place. So this also highlights the need for bringing in the data protection law. So all of these points signify as to how there is a pressing need and why this process of bringing the data protection law needs to be speeded up, and whatever work that is need to be done after the Joint Parliamentary Committee's recommendations, they need to be done fast, and a new data protection law needs to be brought very, very quickly. So this was our discussion with respect to the data protection law, and with this let's move on to our next article for the day. The next article which now features in the newspaper reads, "Proof of War Crimes in Myanmar, says UN." Now, we know that in the country of Myanmar, there's a military rule going on, right? Which we call it what happened a few months ago was the military coup, which was done by the Myanmar military, and that military is ruling in the country right now. So whenever a military rule happens, there increases the possibility of flouting of the rules and basic humanitarian laws. So the UN investigation committee which went to the state of Myanmar has found out that the possibility of commission of war crimes cannot be denied in this particular country, and there are several evidences which suggests that many war crimes are happening in the country. Then when we talk about the Russia-Ukraine situation, this in this context as well, all of us must have read news about this crisis where even in Ukraine, Russia has it is said that Russia is committing certain war crimes in the country. So in this context, where we are seeing that a lot of these crimes and the instances of these crimes are in the news, the concept of war crimes becomes very important, and UPSC can ask a question on this in the prelims examination. So this will become important for us from the perspective of prelims, right? And also in case of GS2, where we study the international relations part. So let's try to understand what are war crimes and how did the prosecution of war crimes come into place. So the genesis of war crimes and what are war crimes came into existence after the world wars. Now during the world war, when the soldiers of one country were inflicting crimes upon the residents of another country, it was identified that these military soldiers should not be devoid of liability, and the crimes they are committing should also be recognized. It is at that point that the concept of war crimes and another known as crimes against humanity were introduced and defined. This collectively is known as comes under the concept of international humanitarian law. So these war crimes, crimes against humanity, collectively come under the bracket of international humanitarian laws. And what are war crimes then? War crimes are those crimes which are inflicted upon the residents of one state by the soldiers of some other party or of some other state, or within the state as well, when there is a warlike situation in the country. And all sorts of crimes, taking of hostages, willful killings, rape and molestation, torture or inhuman treatment for prisoners of war, and forcing children to fight are some of the most obvious examples of war crime. So these are the war crimes, and the definition is established by the Rome Statute of the ICC and derived from the 1949 Geneva Conventions. Now these two concepts are very important. What is the Rome Statute? The Rome Statute was again the statute under which the ICC or the International Criminal Court, this is that court which prosecutes these crimes. So when in the various countries such kind of genocides and war crimes started to happen, which court prosecuted all these crimes? It was the ICC or the International Criminal Court. It's headquartered in the Hague, Netherlands, and the statute which established this was the Rome Statute. Now this Rome Statute tried to deal with these war crimes and crimes against humanity which were being committed in various countries, and 4 conventions were formed enumerating the provisions of these international humanitarian law. These are known as the 1949 Geneva Conventions. These are 4 conventions which deal with the various aspects of war crimes and the type of crimes which happen at these in these situations. So let's look at the Geneva Conventions. What are these Geneva Conventions? So the Geneva Conventions passed in 1949 and their additional protocols. What are protocols? Whenever a convention is signed, let's say some countries come together to decide on an international law, and when they make the law, when they agree upon it, it is known as a convention. So we talk about, we hear about a lot of convention, the Bonn Convention in the environment sector. So these conventions are nothing but agreements. And whenever we talk about the protocols, these are additional amendments made to these conventions. So their additional protocols are international treaties that contain the most important rules limiting the barbarity of war, and they are to protect people who do not take part in the fighting. So these laws are also important because at the time such wars are going on, there are also certain people who are there to aid the people, such as the medical people from the medical sector, journalists who are there to cover the event. So they are for all those civilians, medics, aid workers, and those who can no longer fight. So the wounded, sick and shipwrecked troops or prisoners of war, these conventions are for the protection of those people. So what are these 4 Geneva Conventions? There are 4 Geneva Conventions with respect to this international humanitarian law, which talk about different aspects. The first talks about it protects the wounded and sick soldiers on land during war, so how they should not be harmed. Then the second Geneva Convention protects the wounded, sick and shipwrecked military personnel at sea during war. And the third Geneva Convention applies to the prisoners of war. And the fourth Geneva Convention affords protection to civilians, including those occupied in the occupied territory. These are the 4 Geneva Conventions which can very well be asked in the prelims examination in the backdrop of the increasing crimes in the various parts of the world. And if asked whether India is a party to these conventions, that the answer is yes. India is a party to these 4 Geneva Conventions which deal with the international humanitarian law, such as the war crimes, crimes against humanity. Now, one other important difference which we should also understand is that what is the difference between war crimes and crimes against humanity? So both can be similar crimes. If a genocide is being committed, or as we saw, taking of hostages, molestation, torture, all of these crimes are very similar. But there is a difference between what are war crimes and what are crimes against humanity. So the United Nations Office on Genocide Prevention and Responsibility to Protect, or what is known as the Genocide Convention, separates war crimes from genocide and crimes against humanity. So how are these differentiated? Let's take it from their names. So war crimes has the name war in them. So which means that these crimes would be identified especially when a country is at war either with other country or in itself. There's a civil strife going on. The crimes were committed in these times are known as the war crimes, and crimes against humanity need not be committed during the war times, but they can also be committed in a peaceful time. That becomes a significant difference between these two. So war crimes are defined as occurring in a domestic conflict or a war between two states, while genocide and crimes against humanity can happen in peacetime or during the unilateral aggression of a military towards a group of unarmed people, right? So there are similarities between these crimes, and the differentiating factor is one, that is a war situation is required for the war crimes, and peacetime crimes against humanity can be even committed in the peacetime. So this was the whole concept, important terms related to the war crimes and crimes against humanity, and the important laws governing these concepts. So with this, let's move on to our next article for the day. The next article which comes in the newspaper reads, Bangladesh river water deal likely. Now, if coming to this topic, India and Bangladesh share the longest border. We might feel that it is with China, but India and Bangladesh share the longest border. And by virtue of that, there are various rivers which these two countries share as well. So, in the Joint Consultative Commission, this is that body which deals with the river water sharing between these two countries. It has been meeting for the past several years to come to agreements of sharing the various rivers between these two countries. So, the Teesta River dispute has been a bone of contention for these two countries since a long time, and the current article which features says that this coming meeting that is going to happen between the ministers of these two countries might see the deal between river sharing fructify. So from the examination point of view, what becomes important for us is to look at the rivers that are being talked about, because that can be asked in the prelims examination. So we look at the various rivers which are of importance from this article. So one is the Kushiara River, of which the article says that in the coming meet, when India and Bangladesh dignitaries will meet, might deal and might share the river water. So which is this Kushiara River? Let's take a look at it. So this Kushiara River is from the northeast part. As we can see, this is the Barak River which rises in the northeast, and this is the Kushiara River which flows from the state of Assam, and that then enters into the state of Bangladesh. So it is a distributary river in Bangladesh and Assam. What is a distributary? One is a tributary, which means that small river which ultimately goes on to join a big river. So if Ganga is a river, what will it be its tributary? The Gandak, Son, Yamuna, all of it are its tributaries. What is a distributary? A distributary is that river when a small river separates out of a large river. So Barak river is a large river which flows in Assam, and when a short river just emerges out of a large river, that river is known as a distributary. So Kushiara river is a distributary of the Barak river. This should be remembered, and it forms on the India-Bangladesh border as a branch of this Barak river when the Barak separates into the Kushiara and Surma. So even the Surma river, which is like this is also a distributary of Barak. So these are two important rivers now which we should take a note of, which can be of importance from the point of view of prelims examination. So therefore the waters of the Kushiara thus originate in the state of Nagaland in India and pick up tributaries from Manipur, Mizoram and Assam. And this Kushiara rejoins with the Surma at Markuli in Ajmeri Ganj Upazila and flows south up to Bhairav Bazar. These are all areas of the Bangladesh receiving the name Kalni. And the Kalni meets with the Dhanu, a branch of the Surma, and renamed as the Meghna. These names are not important, but the Meghna river, which is formed in the state of Bangladesh, that is important. So this, I hope the important points with respect to the Kushiara river is clear in this. This is what we required to understand from the examination perspective. Now the second river which both these countries are struggling to deal with is the Teesta river. Let's look at the Teesta river. The Teesta river is a river which originates in the Sikkim Himalayas and then flows from the Sikkim, Bangladesh, then, West Bengal, then into the Bangladesh. This is the river which, as we can see from the Bangladesh region. Let's look at a larger map. If this is the region of Bangladesh, this is where the Sikkim Teesta river originates and then flows into Bangladesh. This is the rough course of the Teesta river. So as we can see, again, this is a transboundary river which is important for the state of Sikkim, West Bengal and even for Bangladesh. That is why both countries are finding it difficult to arrive at a water sharing agreement for this river. So let's look at what the Teesta river says. So the sharing the waters of the Teesta river, which originates in the Himalayas and flows through Sikkim and West Bengal to merge with the Brahmaputra and Assam. So Sikkim is a tributary of Brahmaputra, and Jamuna in Bangladesh is perhaps the most contentious issue between the two friendly neighbors of India and Bangladesh. This river covers nearly the entire floodplains of Sikkim while draining 2,800 square kilometers of Bangladesh. So it's an important river for Bangladesh as well, governing the lives of hundreds of thousands of people. And for West Bengal as well, Teesta is equally important, considered the lifeline of half a dozen districts in North Bengal. We saw it pass through the areas of North Bengal. So this river becomes important for all these two states and the country of Bangladesh as well. So the origin point of Teesta becomes important, and where it flows from, that also becomes important for us from the examination point of view. So with this, we finish today's articles and the important parts from these articles, and we'll meet again next time with the important articles from the newspaper. Thank you.